The Town of Los Gatos Planning Commission meeting of Wednesday, October 9, 2019 is now called to order. Please take a moment to silence your devices. Ms. Arnowitz, could you please call the roll?
Yes. Commissioner Badami?
Here.
Commissioner Tavana?
Here.
Commissioner Janoff?
Here.
Vice Chair Hansen?
Here.
Chair Hudas?
Here.
Thank you.
I would ask that everyone stand and join Commissioner Janoff in the Pledge of Allegiance. As the Planning Commission conducts this meeting this evening on behalf of the Town Council and residents of Los Gatos, we encourage active participation, which is essential for democracy and critical to the work of the Planning Commission. That participation can occur through written comments about agenda items submitted to staff prior to a meeting, which are always welcome and helpful. And during our meeting, there are two opportunities for members of the public to participate. During the verbal communications period, an individual may speak on an item that is not on the agenda, and during hearing on a specific agenda item, any member of the public may speak about that item that is on the agenda. If you wish to address the Commission tonight during verbal communications or during consideration of an agenda item, please fill out a speaker card. The speaker cards are located on the back of the benches where you're seated. Please turn the card into a staff member and please print your name clearly. When you speak, I ask that you come up to the podium and adjust the microphone so that you're speaking directly into it. Please state your name and address for the record. In fairness to all who want to speak at this meeting, it is requested that you limit your comments to 3 minutes. So the first opportunity to speak is verbal communications, where any member of the public may address an item that is not on the agenda of the meeting, and I don't see any cards here. Do we have anyone who wishes to speak on an item not on the agenda? Okay. When you are speaking with the 3-minute time limit, there is a yellow light that comes on, which means you have 30 seconds left, and when the red light comes on, it means your time has expired. We have 2 consent items to be acted upon as single motion. Before the Planning Commission acts on the consent calendar, any member of the public or commission may request that any item be removed from the consent agenda. At the chair's discretion, items removed may be considered either before or after the public hearing portion of the agenda. So with the 2 items that we have, approval of the minutes, September 11, 2019, and architecture and site application S-17-047, 16 Chestnut Avenue. So before I call for a motion on the consent calendar, I would ask to pull item 2 for further discussion. So the first item will be, so the only item will be approval of the minutes, September 11. Do we have a motion on the consent calendar? Commissioner Badami?
I move to approve consent item number 1, which is the minutes of September 11th, 2019.
Okay, thank you. Do we have a second? Commissioner Janoff?
I'll second the motion.
Okay, all in favor? Opposed? Okay, thank you. It passes unanimously, 5-0 tonight. We now will consider the item that was pulled, item 2, architecture and site application S-17-047, which is project location 16 Chestnut Avenue, property owner Kim Roper, applicant appellant Bess Wiersma, Studio 3 Design, project planner Aaron Walters. Consider an appeal of a development review committee decision approving a request for demolition of an existing pre-1941 single-family residence and construction of a new single-family residence on property zoned R112, APN 510-40-012, and they are requesting a continuance. And let me just say that the reason I pulled the item is that under the new rules, I have a potential conflict since it now falls into the 500 to 1,000 foot from distance from my residence. So we're operating now with 1,000 feet zone, and so I will recuse myself from that item. I am permitted to stay since it's not, since it's a continuance, I believe. So would anyone like to begin discussion on that item or make a motion on it? Vice Chair Hansen.
I move that we grant the continuance.
Okay, we have a second. Commissioner Tavana?
I'll second that motion.
Okay. All in favor? Opposed? Okay, passes 4-0 with one recusal. Okay, thank you. We now move to item 3, which is public hearing portion of our agenda, and it is architecture and site application S-18-050, project location 56 Central Avenue, property owner Andrew and Ashley Bothman, applicant Rick Hartman, Home Tech Architecture, appellant Leslie Morley, project planner is Jocelyn Schupman. Thank you. I'll wait a moment to take some cards so that we can get testimony. But as we get ready to take public testimony, may I have a show of hands from commissioners who visited the property under consideration? Okay, are there any disclosures? Okay. Ms. Schupman, I understand that you will be giving the report, and I believe, according to our current procedural rules, after you speak, when the public speaks, the appellant will speak first, and then the applicant, followed by public comment, and then the applicant, and then the appellant, and each person speaking will have 5 during the first round and 3 during the concluding. And of course, the public always has 3 minutes. So Ms. Schupman, could you please tell us about this?
Good evening, Chair, Vice Chair, and Commissioners. Before you is a proposal to demolish an existing dwelling and construct a new single-family residence with reduced setbacks on a non-conforming lot and the removal of large protected trees. The existing lot is non-conforming with regards to its frontage, where the minimum frontage for an R110 zone is 80 feet and the existing frontage is 50 feet. Pursuant to the town code, any rule of the zone, including front, side, and rear setbacks, can be modified by the terms of an architecture and site application. On July 30th, the Development Review Committee held a public hearing for the application where 2 neighbors raised concerns regarding the project. The Development Review Committee continued the application to August 13th in order to allow the applicant time to address the concerns raised. At the August 13th meeting, based on compliance with the town code and the hillside development standards and guidelines, other than a cut and fill exception for a portion of the rear yard, the Development Review Committee approved the application with added conditions of approval addressing privacy concerns that are contained in conditions 4 through 6 of Exhibit 3. An appeal of this decision was filed by the adjacent property owner, and a detailed discussion on each point of the appeal is contained in pages 7 and 8 of the staff report. In response, the applicant also submitted a letter addressing the points of the appeal, which is contained in Exhibit 14. An addendum report was distributed to the Commission, which includes an additional letter from the appellant and attachments, and that's been distributed to you this evening. Based on the analysis provided in the staff report, staff recommends denial of the appeal, upholding the decision of the Development Review Committee, subject to the recommended conditions of approval included in Exhibit 3. This concludes staff's presentation, but we are available for questions.
Thank you, Ms. Schupman. Are there questions? Vice Chair Hansen?
I just had one clarifying question on page 5 of the staff report, the neighborhood compatibility. It says that the residence would not be the largest home in the immediate neighborhood in terms of square footage or FAR. One of my questions was, because of the nature of some of the properties there with the slope lots, do the applicants proposal does reflect the adjustment in square footage in terms of calculating their FAR, but do the neighbors?
So the applicant's property takes into consideration the reduced net lot area based on the slope, but staff doesn't have the information on all properties within this table and their average slopes, so the FAR may be adjusted. However, the floor area, the actual square footages, are the numbers that the town has on each property.
And if there was other properties that had slope lots, then their FAR would be understated?
Potentially, yes.
Okay.
Other questions? Okay, thank you. So I will now invite the appellant, Leslie Morley, to speak, and you will have 5 minutes, and you'll get plenty of warning with a yellow light.
Hi, my name is Leslie Morley, and I live next door, and I was the owner of the lot before the Bothmans bought it. They used 60, 64, and 70 and possibly their own for justification of reduced setback. I don't feel
I wonder if you might speak up into the
Oh,
microphone,
sorry.
please. That'd help.
Okay. So they've used lot 60, 64, and 70 for justification that the neighborhood it fits in with the neighborhood for a side setback on 5 feet of each side. I walked the street. I have lived there for 28 years. No one has 5 feet on both sides except for lot 60, which is where my house is. And that's only because the house was built in 1928, and when it was extended, I didn't own it then, but, it's an oversight, I would say, on the, it was either done at midnight or, not with permit or whatever. But I don't think that's fair justification to repeat the same situation. We have lots of subdivisions in Willow Glen and Rose Garden that are 50 foot. They're generally 10 foot on one side and 5 foot on the other. They have a driveway on one side. This property has a driveway on one side, and then it has, my house, which is very close to the property line. It may be at 1.4 feet from the property line. I have a 7-foot deck that goes out, and so my deck railing would be over the property line in part. We don't know where the property line is because the survey hasn't been done, but that puts their window 5 feet from my deck. And they did not do a rendering of my house compared to their house, first and second story. I have looked at these plans, spent a lot of time trying to understand where things would be and how it would affect me. And when I went to the DRC meeting, I thought that it was the second story that was going to affect me most, and that's what I concentrated on. And I asked them to reduce the windows, which they said they would. I asked for screening because there was no screening proposed. We've talked about it a little bit. But it's the first story that is amazingly obtrusive. Their first story is going to be, their window in their kitchen is going to be right next to my balcony, and it's 4 by 5 feet, and they will be able to be looking through my railing right into my master bedroom. I have pretty much all glass. I have 12 feet of glass on that side of the building, and I wonder if they just didn't put that rendering in so that, I wouldn't notice. And I also looked at the streetscape that their architect did, and that's totally in error because there's elevation difference between the two lots. They put us on the same level, and they also put us further apart than they are requesting. They put us at least 10 feet apart where they're requesting 10 foot, 15 feet, I think, or something. If you look at it, it's wrong. So I had another architect look at it and draw it for me because I couldn't work it out in my mind. So you have a copy of that. The closeness to my house is the biggest objection I have. No other property in the neighborhood has 5-foot setbacks on both sides. I know in your code there is a point that says that when you are building a new house, that you should keep the windows to a minimum. You should be aware of how you're obstructing or, affecting a neighbor. And they never discussed anything with me. They haven't shown it in their plans where the windows are. And I think to give them a reduced setback so they can maximize their square footage is wrong. The overall square footage for homes in our neighborhood is 2277. And there are only 4 homes on the street that are over 3,000, and they are proposing almost 4,900. And to give them a reduced setback where they're going to affect my personal, privacy and and the value, I can't believe it. Anyway,
Okay, thank you. There may be some questions for you, so
sure.
please stay there. Yes, Commissioner Badami.
You expressed concern over accurate measurements of the property lines.
They're 50-foot lots. I think the lines are probably correct, but we don't know where they are on the land.
Okay.
And I asked the engineering firm, and, they can do a line, but they haven't, so we don't know how it falls.
Okay, you're the owner and you were the listing agent as well, correct?
Yes.
So,
If you don't mind, please step back to the microphone.
Okay.
Or you can take it with you. We just want to
Oh,
make sure that we hear
Thank you. Okay.
okay. So having a considerable interest in the properties, in the land, did you consider doing your own property survey?
We had a survey that was of the 3 lots that are there.
Okay.
And I can provide that to you if you don't already have it. Yes, we had all 3 of them drawn, but we've never, it's hard with 220 feet. If you swing the line ever so gently, you're off. The corners aren't marked.
Okay, because usually when you have a survey done, it's the engineers mark off the property so you know where the property lines are. So
They did
didn't do
not
it.
mark off the properties.
Okay, thank you.
Thank you. Vice Chair Hansen?
The applicant, in their justification letter, mentioned that there's plans to remove the house that you're living in. And if I understand it correctly, that right now there's 2 lots and it crosses over both of them. So is there merit to that discussion?
So
That they mentioned in their letter?
no. Right now, I've lived there 28 years. I don't know what's going to happen on it. There's lots of things going on. I have health issues. I don't know if I'm going to ever do a build or not. So, I can't, I don't know.
So at this time, you don't have any plans to
no plans,
renovate
no
or
plans
to move the house?
To change the house on 60 at the moment.
Okay, and then just one other quick question. Are you aware that the town does not count cellar space in square footage? Because you mentioned 4,900 square feet, and are you aware that we do not count that
I'm
in
aware
our,
of
in our
that.
code?
I realize that they are at the maximum that the town would allow, but I know I'm also a real estate agent. The square footages I calculated for the street in the neighborhood were on accurate square footages that were supplied, and those would include habitable space. So when it would go on the market, it would go on the market at 4,900 or whatever the number is.
I certainly understand. I just wanted to make sure you were aware of our town code that
Right,
we have to
right.
live by. So,
I just
okay.
don't think that they should get special consideration for a reduction that's going to affect me in order to maximize this number, without having considered me at all when they designed the house. They never brought anything up or showed me anything.
Okay, thank you.
Commissioner Janoff?
Yes, thank you. A couple of questions. Also in the applicant's response, they talked about a 5-foot setback having been discussed prior to their purchase of the property.
Yes.
And submitted an email that is from you to them that indicates the town said it will be a 5-foot setback and that should be a contingency of the sale. Can you comment on your endorsement, if you will, of a 5-foot setback then versus now?
I never endorsed. I was trying as a Realtor to be accurate, and at the time, Irwin O'Donis had said it would most likely, it could go to a 5-foot setback. Then I checked with Joel Paulson, and I gave them the exact wording of the code, and said it would, it would be decided at the time of application and whether or not it was consistent with the neighborhood.
So just to clarify, but you were aware, having had a correspondence with the applicant, that they could have potentially a 5-foot setback legally?
They could have potentially a 5-foot setback. I was
Okay.
just saying what they could have. I never said I would agree with it. And I told them specifically, if that was important to them, that they put it in their contract as a contingency. They did not. They removed all contingencies.
Okay, second question, if I might.
Yeah.
If I'm not mistaken, somewhere in the documentation that we received, there was an indication that the property line ran through your balcony and that the balcony would need to be removed as a condition of not encroaching on the neighboring property. Can you comment on that? Is that still the case?
Sure. We don't know exactly where it is. As I eyeballed it, I thought that maybe the first post, my house angles away from the property line. So the beginning, from the corner of the house, I thought that first post might be encroaching. We don't know exactly where it is. I want to keep a balcony. If it has to be reduced, it has to be reduced.
So just to clarify, on the desk item that we have in front of us from you, I believe it was dated a couple days ago, or the drawing that you provided, drawing number 1, does show a lot line. You're suggesting that it's not.
Excuse me, just 1 minute. Maybe we could put that drawing up, because there may be other questions on that as well.
And that would be their view into my master bedroom.
So I'm referring to this drawing that was part of the desk item we received.
Is that number 1? or-
Number 1?
We're going to put that up on the screen so we can all see it.
Okay.
So this was a drawing submitted by you in your package, perhaps drawn by your architect.
Yes.
But it clearly shows the assumed property line running through your balcony.
Yes, it does.
Okay, thank you.
I just wanted to ask maybe one follow-up on that. What is the setback of your house to where you believe the property line is?
I'm not sure, but I think that first corner might be 4 feet from the line. But you have to realize we owned all 3, and that was done by somebody before we bought. And just because one person made a mistake, I don't think that's justification to make the house next door so close as well. I think, in fact, it warrants it being a 10-foot setback because it's already so close.
Okay, so if I might.
Yes.
So you were the owner at the time that the map was redrawn, is that correct?
Yes.
Could you have drawn that line 10 feet over?
What do you mean?
10 feet so that you would have a full setback for your home?
Oh, we didn't subdivide this land.
Okay,
The lots
That's what I'm-
already existed.
I see, okay.
And I don't know, they were owned originally by 3 different people. Over the years, one person bought something else. One of our town mayors owned the house before I did. But add-ons were done. The cottage is built on their lot, right on the line. I don't know who approved that, you know. It's
But,
just-
but to the best of your knowledge, you think your property is about 4 feet from that property line?
Just the corner of my house, not the balcony, but the corner of my house possibly, and then the next corner would be probably over 5 feet. I mean, you know, it's definitely over 5 feet, but it's like just a very little bit of the house might be 4 feet.
Sure, but a setback works from any point on the property, on the
Okay.
structure. So-
Okay.
Okay, thank you. Other questions? Yeah, Commissioner Badami.
I just want to go back to the email exchange that Commissioner Janoff had brought up, because I was concerned about that as well. In our packet, it's considered Exhibit 14. But when we read the email exchange, there's no coulds in there, or possibly. It says this home will have 5-foot setbacks, and that was authored by you. So was it your understanding when you sold this property that
Okay.
you have that expectation that this is a very real
No.
possibility?
Possibility, I told you I got the information from Erwin O'Donis that it was likely it could be 5-foot setback. Then I went to Joel, didn't want to make any, you have also what Joel said.
I have that, yes.
Yes, and I had told them if it was important, that they needed to make it a condition, that they have the right, you know, this was before they got into contract, they could make it a condition that they asked for, they had a 30-day, I think they had a 30-day contract, they asked for 2 30-day extensions, they had plenty of time to talk to the town, and they had the information from Joel and his saying, have them get in touch. And it wasn't, you know, for me, whatever the town rules were, you know, okay, but, you know, when I checked the neighborhood and then I realized that they were going to build right next to my house and they were going to have windows on the, you know, that the difference in elevations and all this stuff, that, you know, I just, you know, I couldn't believe that they would do that. I thought they would have consideration.
Okay, thank
Thank
you. If it's not directly pertinent to the first round of testimony, I'd like to move on, and then we'll have an opportunity to come back. So thank you very much.
Okay.
And I'd like to ask Andrew and Ashley Bothman, as the applicant on 56 Central Avenue. You have 5 minutes, so please come forward. And again, you'll have a second opportunity to speak as well. So, and there may be questions after the 5 minutes. Thank you.
Thanks, Jocelyn. Hi, my name is Ashley Bothman, and I'm representing my husband Andrew and I and our daughter Juliana for 56 Central. Today we're going to discuss, I'm going to just talk through the appeal comments from Leslie, specifically around the 5-foot setbacks, height concerns, and her balcony concerns. We provided a detailed and formal justification letter to address the 5-foot setback concerns. However, I'll summarize here our justification. You can see the image here of 64 Central Avenue, which has an 18-inch setback from the fireplace and a 4-foot setback from the house property line, which is directly next door to Leslie's. Secondly, you can see the property at 67 Central Avenue, which also has 4-foot setbacks. The third example is 71 Central Avenue, which also has 4-foot setbacks. And the fourth example at 70 Central, which has 4-foot setbacks. In total, we found 4 properties with less than 5-foot setbacks, which demonstrates that our ask of the 5-foot is consistent with the neighborhood. In addition to, 56 Central is a non-conforming lot, which cannot be accessed from Oak Hill. So a garage cannot be accessed via the rear of the property. Also, the property directly next to 56 Central is a flag lot, which means that the house on the other side of the property will never have a house roughly within 50 feet or so from our proposed home. And for the last justification, I want to provide a little bit of context on our conversations with Leslie. So Leslie, the appellant and neighbor, was not only the seller and property owner, she was also, as you know, the listing agent and had sold us the property directly. before closing on the property, the general plans of a 2-story home, specifically with 5-foot setbacks, was discussed with Leslie multiple times. You can see here and included in our formal response the email from Leslie, which is dated to prior to the close of the property, where she recommends to us that we should make the setbacks 5 foot a contingency of the sale of the property. She even reached out to the Community Development Director, Joel Paulson, on our behalf to set up an informational meeting, which we attended, and Joel was very helpful, showing Leslie's support of the 5-foot setback prior to the close. You can see how this has been a very frustrating situation where we were communicated a very different message prior to the close of the property. And then once Leslie closed on the property and received her compensation, is taking a very different stance. In regards to the height and square footage concerns, all of the plans have been very carefully crafted to meet all of the town guidelines for height and square footage. In regards to Leslie's concerns around her balcony is currently over the property line on 56 Central, and it has been communicated by Leslie to us multiple times prior to the closing of the property and after. That is to be removed in order to be compliant with property lines. Since we last met on July 26th, we have spent countless hours, whether in person, phone calls, texts, emails, doing our best to work with Leslie and to find a middle ground. To address all of her concerns, we have added 6 screening trees total for her privacy, a screening wall on the master bedroom balcony for her privacy. We've raised our windows on the south side of the home for Leslie's privacy, and we're going to be constructing a brand new 6-foot high good neighbor fence at our expense for Leslie's privacy. In closing, I think it's pertinent that you know we're just a young family trying to live out a lifelong dream of moving to Los Gatos. We have a 1-year-old daughter, Juliana, and are now expecting our 2nd child. And since my husband grew up in the town of Los Gatos, it's always been a dream of ours to move into this town and raise our family here. We're just a family looking to join this amazing community and raise our children here. We've been looking for the right opportunity for a few years, and when we found this spot, it felt perfect for our family. We wanted you to know we're not developers. We're not looking to build and sell this home. We're just looking to raise our daughter and future children in this neighborhood. We hope that after tonight's review of all of the work we put into addressing Leslie's concerns and accommodating them, will help show how invested and excited we are about this new home. We want to continue to build close relationships in the community as we plan to live our lives out here. We're hopeful you'll support the DRC's previous approval of our plans.
Thank you.
Thank you.
There may be some questions, so are there any questions? Commissioners, Vice Chair Hansen.
I was just wondering if you could comment. I mean, it came from the appellant directly with the drawing with the property line running through the balcony, but what is your understanding of the surety of what the property line is? Was any kind of work done to verify, at closing where the property line was?
Yeah, it appears that Westfall Engineers, who's here today, the civil engineers did a topographic survey of all the lots and then also verified via a new topo before we finished all our plans, verifying all the property lines and locations of everything. So that's all shown. You can see the balcony and a slightly dotted line on multiple civil engineering stamped drawings that verify that line.
So there is no question about where the property line actually
Not in
is?
our opinion, no.
Okay,
Yeah.
all right, not in your opinion anyways. And then one other quick follow-up question. The appellant mentioned in her testimony that she was aware that there was some changes that had been made, but she mentioned the first floor as if it was a new thing. I was just wondering if you had talked to her about the first floor. It seems like it's all related to all the accommodations that are already terms and conditions in the conditions of approval. But if you could just comment on to make sure that So is there anything else that you can do, or do you feel that you could do to improve the privacy? It seems like there's quite a few things already. Is there anything else that you'd had talked to her about that you could do?
As she has a limited look onto our property, that looks at this foliage, trees and stuff, would be nice, but we're willing to accommodate potentially.
Okay, thank you.
Other questions? I had a question. In the Development Review Committee meeting in July 30th, they noted in the minutes that conditions of approval could be added that along the southern elevation adjacent to 60 Central Avenue, number one, windows to be clear story or frosted. Number two, the balcony be screened with vegetation and/or lattice. And number three, additional screening trees be planted. Were those measures all incorporated in the design? And as you understand, are they reflected in the conditions of approval?
Yes, they were not in our original design, but we did add all of those conditions and adjusted our plans accordingly to accommodate.
Okay, thank you. Other questions? I had a question on a different topic a little bit, and that's about the trees. I looked at the report, and I wondered, there are two trees, there are 8 trees that are slated for removal, I believe, and tree 526 and 527 are considered large, protected trees. Have you looked at the possibility of saving those 2 trees? I wonder if you might speak a little closer to the microphone. Not positive that it's working. No, it seems like it's not working. Just if you just take a moment, we'll replace the batteries or the mic so that everyone can hear. Okay, so again, my question was about trees 526 and 527.
Yes, we did review those, and we reviewed it with our design team as well as reviewed it with the arborist, and both those trees were in fair condition, which there's a description of what that means exactly in our response, but they're also highly impacted by our foundation and our improvements. So there's a safety concern on top of them already being in fair condition and recommended for removal by the arborist.
Okay, thank you. Okay. No more questions, then we'll open this to the public, and then the appellant and the applicant will have, I believe, 3 minutes to respond after we hear from the public. So I have several cards here. The first one is Susan Branch, followed by Susan Barden.
Good evening. My name is Susan Branch. I live at 7 Central Court, and I'm going to read my testimony, and I apologize for that, but I wanted to meet your time limits.
No problem.
The town's approach in granting an exception to the required setbacks of 10 feet will make 5 feet the de facto setbacks in our neighborhood. I was told that the town considered the lot, that the lot is non-conforming in size and that 3 residences have setbacks of less than 10 feet, and on that basis, the applicant need not make an additional showing. I would point out that all of the lots in this neighborhood were originally subdivided, which were originally subdivided sometime in the 1800s, were originally 50 feet wide and potentially non-conforming, yet the majority of the residences have 10-foot setbacks. If other lots are developed, the standard applied here will be cited as a basis for other exceptions. The side setbacks being requested here are not the same as that exists in the neighborhood. The applicant seeks to build a large house with both side setbacks of 5 feet. It seems to me that that will magnify the impact of the house, particularly since all the existing trees will be removed. The 3 houses cited by the applicant in support of the request have only one side setback that is less than 10 feet, while the applicant is requesting both side setbacks be 5 feet. If the width of the setbacks of those houses were averaged, they would definitely exceed 5 feet. In one case, the average would definitely exceed the zoning requirement because the other setback is 35 feet. When Mr. Flick developed numbers 39, 45, and 51 just across the street a few years ago, he requested a reduction in the side setbacks. The request was denied by the Planning Commission, and 3 very lovely functional homes were built. I would request that the Commission deny the request for reduced side setbacks.
Thank you. Are there questions? I actually did have a question. How close are you to the subject property?
I live in Central Court, so it's like half a block down and kind of that way. My house is one of the older ones built before the San Francisco earthquake, and it sits on what were originally 2 50-foot lots. The town required that we remove our lot line when we requested to build a garage.
Okay, and so I assume that your property meets the setbacks?
It wouldn't probably meet the front setback because the original house was built about 19 feet from the street, but it has 10-foot setbacks on either side.
And it's a double lot, essentially, is that correct?
It is a 100-foot lot now.
Okay, thank you very much. Susan Barden, and then followed by Karen, I'm sorry, I can't quite make it. Rogi? Okay, thank you.
Hi, my name is Susan Barden, and I reside at 16386 Lilac Lane, Los Gatos. I've been a Los Gatos resident since 1986. I didn't bring any prepared notes. I just came to speak in support of Andrew and Ashley Bothman. I've known the family for known Drew for over 25 years. They're a wonderful family who will make an incredible addition to the town of Los Gatos. We need young families. We need to continue to build a balanced community. I would also like to say that I'm well familiar with the street, and I believe that the property that they're going to be, the home that they're going to be building on that property is going to be a dramatic improvement. I think it will really add to the street and to the overall ambience, and I'm really hoping that you guys will approve what they want to do. I really appreciate this opportunity to speak. Thank you.
Thank you. If I might just ask one question, are you a close neighbor of the subject property?
No.
Okay, thank you. So I'd invite Karen Raggi and then Christy Harmon.
Good evening. My name is Karen Rogi. I live at 70 Central Avenue, which is just a few houses down the street from the from the property that we're talking about. Okay, and I'm very happy to see that somebody wants to renovate that property. On the other hand, I would like the new building going in to fit within the neighborhood and the street. So if I can give you some description of the street, some of you have been to see it. You can see on the end of the street with the subject property is the historic Florentine Village. So take yourself back to old Los Gatos. Next to that is 44 Central Avenue, which is over 100 years old. So a small little bungalow and a few little shacks behind. Then you have 50 Central Avenue, which Ashley's right, has a long driveway with a flag lot. And then you get 56 Central Avenue. Now, when you look at the pillars for 56 Central Avenue, I have to tell you that the elevations may not have been rendered right on the drawings that you're seeing. Leslie mentioned that, and others will mention that later on today. But it's actually probably 10 feet higher than any other property on the other side of the street, not to mention the 100-year bungalow next to it. The side, trying to fit a huge 3,500 square foot home into this little lot makes it look like high-density housing and doesn't really fit with this historic rock wall, wrought iron, gated community. So I am very much in keeping with the standard setbacks. The other item that I'm concerned about are the number of historic trees on the property that are being removed, both to build the house, but further in back to put in a pool. I would say that we should really try to keep those historic oak trees on the property. And then the last concern that I'd like to bring up is the grading of the property in general, to put in a cellar and further increase the square foot of the property. We have a huge problem on Central Avenue. You know, Central Avenue is at a higher elevation, and it backs down into Oak Hill Way. We've had significant erosion on that hill, and my concern is that any continued grading would add to those problems. Thanks for your consideration.
Thank you. Are there questions? Vice Chair Hansen?
Thank you for your testimony. You mentioned the square footage of 3,500, but in our packet it says 2,665. So what's the difference?
2,665 is the home itself, and the additional 1,500 square feet is for this walkout cellar, which leads down to a pool that's going to take further grading on the hill.
Are you aware that our town code doesn't count cellars? And the express purpose for not counting the cellars in our code is to avoid massing above ground. But are you aware that we don't count that?
I'm
the
aware
official
that
square
you don't
footage?
count it,
Okay.
but I'm also aware that construction on this property will excavate and affect the overall grading of it, which is already an issue with the erosion going down into Oak Hill.
Okay, thank you.
Thank you. I had another question, if you don't mind. Are you a close neighbor of the subject
Yes, I am.
property? And,
So I am at 70 Central Avenue, which is a corner lot.
okay. And do you know if your setbacks
Yes,
are?
my one setback, so what's Dan? Dan is 64 Central. So Dan's driveway is next to me, which has a 4-foot setback on that side, and then I'm the corner lot. So I have this huge view that goes across Oak Hill and the street.
Okay. Thank you very much. The last card I have is Christy Harmon. I'm not sure. Erickson? Harrison. I'm really sorry. I'm having a hard time with handwriting tonight. I apologize for making a mistake on your name. Yeah, absolutely. You could just get to share the time, that's all.
I am not sure how to use this. This home right here and this home right here, this is the opposite way. This home, these are some of the homes that Dave Flick built.
Oh, mine, thank you.
These are some of the homes that Dave Flick built right across the street. So I'm Christy Harrison. This is my husband, Eric Harrison. We are immediate neighbors on the other side of the new property. These properties actually, I don't know if you can see, these step down from street level, from street grade. So when this property was originally developed 18 years ago or so, for whatever reason, Dave was not, it was not requested that he bring these properties up to street level. So this house, 2 doors up, is the subject property. So their house, even though it is at 28 feet will be at least a half of a floor above these these three houses that are immediately across the street. It's gonna tower. It's hard to see that because from the street level, you don't look that you step down 4 or 5 steps for each of the houses. We are, as Karen mentioned, this would be an incredible improvement to the property. The structure that's there is old and definitely is not terribly charming. It would be very nice to have something newer and lovely and with a new family, and we're not at all opposed to that. I think what we're concerned about is 3 out of the 4 properties that they mentioned that have 5-foot setbacks are on Upper Central. And Upper Central really does have a very different feel than Lower Central. You cross an intersection of Oak Hill and of Jackson, and one way you go up to Upper Central, the neighbors are much closer together. The properties are much closer together. On Lower Central, the whole kind of that little area there has a much different feel because the properties are older, they're larger, I think Karen mentioned, they're historic. Some of the properties are historic, and they have a lot more space. They have a lot more trees, and I think people gravitate to the neighborhood because they do like the tree-lined, large oaks, and we want to keep those trees. There's a reason that those are protected, and we are also requesting that you please honor the setbacks. We want the neighborhood to feel the way that the neighborhood feels now. If we reduce that to 5 feet, it will change how our neighborhood feels. Thank you.
Thank you. Questions? Oh, no, go ahead. You still have a few minutes.
Sorry, just one quick note. Well, my 8 seconds. I think it's just, and I forget what the square footage is, 4,000 and some change or something. Anyway, it's just simply too big for the narrowness of the lot. So, and I realize I'm kind of coming in at the last minute, but anyway, that's my only comment. Thanks.
Okay, thank you. There may be some questions. Commissioner Badami.
Can you clarify for me, do you live on the same side of the street as the appellant and the applicant?
Yes.
Okay, and the Flick properties, they're on the other side of the street?
Correct. Correct.
Okay, because we don't know what happened when they were approved, and we don't know if they were non-conforming lots. So what we're looking at,
Non-conforming lots. He took one property and subdivided it into 3.
So that's a
doesn't-
question that we can ask of staff, so just let's try to respond to Commissioner Badami's
Okay.
question.
because sometimes non-conforming lots, there's different situations that exist where we do look at maybe giving a reduced setback that isn't necessarily a variance. And with going down that street, there is different topography on both sides of the street. So that's something we have to look at. And again, we don't have all the information on the Flick properties for comparison purposes as to why they have 10-foot setbacks, et cetera. And that's maybe something, as Chair Hughes said, we can get more information on.
I'm sorry, can I mention, there is actually a question on our side on the property line. The last survey that was done, the stake does actually go through what is now their shed. So.
Okay, thank you. My question was answered, and yeah, the 3 minutes is up, so thank you very much. Unless there's further questions.
I actually did. You are a nearby neighbor of the subject property, correct?
Correct.
Immediate.
Immediate, right?
Immediate.
Okay. And are your setbacks conforming?
Oh, yes, easily. Probably. Our setbacks are probably
Probably 50
20 feet or more than that on
Right.
50 Central, correct?
Okay, great. Thank you very much.
Thank you.
Okay, that's the last card that I have from the public, and so we now come back to the applicant, Andrew and Ashley Bothman. You will have an additional 3 minutes, and then the appellant will have the final 3 minutes. So if you'd like to address anything that was said or anything that you didn't have time to address, please feel free. You've got 3 minutes.
Excuse me. I would just like to say, I think we kind of shared all of our thoughts and have provided a lot of information in our justification letter. I don't think we have anything additional in terms of the comments that were said. I think they were all a part. We've addressed all of those in our justification letter. Just want to thank you for your time and hope that you'll consider the DRC's review and our review and in support of the project. I think another thing that has been brought up, maybe that I didn't address very much, was the height concerns and grading and that sort of thing. But it has fallen within the town's guidelines and was approved as a part of the process. So it's a tricky lot, and it was a lot of work to figure that out and meet that. And I think with our engineering and architect team in partnership with the town, we were able to figure out that puzzle. So we're grateful that it met the guidelines. Thank you.
Thank you.
Sure. Any questions? Vice Chair Hansen?
You had mentioned earlier about civil engineering. So I was just wondering if you could respond to the issue raised about the possible erosion. So I'm assuming in order to get your plans where they are even now, you would have had to have a civil engineer come in and assess the feasibility of digging into the hill and making a pool and all that stuff. So could you please comment on that?
Yeah, we don't necessarily agree that there's going to be an erosion impact based on the construction. You can come up too if you want. But we are actually, there's some retaining walls that are falling apart there now. So we're actually going to be improving a lot of the erosion components. We also have an erosion control plan that will minimize any type of erosion or sediment control. We'll comply with the SWIP regulations for the stormwater pollution prevention program as per the state. So all of that taken into account, we don't believe that there will be erosion concerns.
And you did hire a civil engineer to assess
she's here too, yeah. So everything has been reviewed and designed by a licensed civil engineer.
Okay, well, I don't know that we'll have more questions right now, but if we need to call her up later, we can do that because she's here. Right?
Yeah, no problem.
Okay.
I actually did have a question.
Yes.
Of the civil engineer.
Okay.
There's been some question about whether a survey was done and whether that information was available to the appellant. Could you comment on that and whether the survey information was available as part of your package that you submitted?
Our company, our surveyor, our company did the survey, topographic survey. Initially, we did the survey for all 3 parcels, which is includes the next door 2 properties. And at that time, we also were showing the property line. We did not establish property corners. We started from monumentation, which is available in the neighborhood, and retraced the survey based on a recorded map. To establish property corners, because this original survey was very, the map which divided the properties is very old, we would have to, record a record of survey map, which was not. Sometimes you do it only when you need to stake the property line, and so that was not the case over here. So we were just showing it on a map, and it was clearly indicated that the lot line between 56 and 60 runs through the deck and is very close to the existing home. So there was never a question. And also it runs through, I think it's a shed in the back.
So if I just may follow up, was that information about the survey provided in your application that's part of the public record?
Yes.
Okay. And do you have a comment on the drawing that the appellant's architect provided showing a dashed lot line between the 2 properties? Does that appear to be about accurate?
Yes, it appears accurate. Yes.
Okay, thank you. I had one more question, if I may. I just wanted to go back to the design of the house and the decision to design the house into a 5-foot setback. So I guess the question is, did you consider designs for the house that might have been smaller and that might approximate a larger or even a conforming setback?
Yeah, we went through a lot of iterations with the design team. We have a lot of restrictions with the elevation difference from central to Oak Hill, which is about 40 feet. In addition, we can't have any access from Oak Hill Way based on that elevation difference. And we didn't want to disturb the land at the lower end of the property, leaving those trees and those shrubs and, concerns about erosion. There's all these things that we're, trying to plan around. So we spent countless hours. I mean, we're a year and a half in the process now with the design team, trying to see how we can minimize, impacts to the community, but also maximize, our square footage, which is actually 2,600 square feet, which I know there's been numbers flying around from 5,000 to 2,000. But that doesn't take into account the cellar and the garage, right? So, yeah, we did go through that process quite a bit and did everything we could, but if we used 10-foot setbacks, we would only have a 30-foot wide house, and it would be very difficult with the elevation changes and the grading requirements to really make that happen.
Mm-hmm. Okay, thank you.
Thanks.
I don't have any other questions, so Ms. Morley, I believe you can address any of the things that came up or any other points that you'd like to add, and you'll have 3 minutes. Thank you.
Okay, so this is the streetscape that they provided, and they did not, in that year and a half, come to me once until, I saw the plans when the DRC.
Could you please speak
Sorry.
into the microphone? You
Sorry.
can start again. Thank you.
Okay. So I was not aware of any of the plans until there was a posting on the property for the DRC meeting. And this is what was in the package, showing my house and my deck well off the property line there, which is totally inaccurate.
Which one is your house, please?
My house is, this house. It's 60. The numbers on these are incorrect too, but there were other errors as well. But that's my house, and it's much closer. My deck, this line goes through my deck. So put these together, and their windows are going to be right opposite and looking into my master bedroom. The code says they should take into account, issues of existing houses. This I took from their property, and this flagging here, the lower flagging, is the top of the first floor. That's the top of my second roof, the roof on top of my second story. I didn't expect the first story to be on, at my level. So their kitchen window is going to start right above the sink, above my balcony floor. So there's just, the faces, they're going to be right there. We could cut the balcony back to where the line is when I know where the line is. It hasn't been sited on the ground. I've asked for that all along. I would have liked to have known where the windows were. They didn't do a drawing to show the relationship between my house and their house, probably because it would have been very obvious, the intrusion. This house here, they want to take all the trees down. This house here is right across the street. They don't have trees in front, like the new house won't have trees in front. And I think it's very stark and not in compliance with conforming with the neighborhood. This is one of the trees they want to take out in front, not anywhere close to their house. This is a blue oak that is in good condition. They want to take out. And they want to take out 6 other large trees. Environmentally, I think it's a mistake to take out mature trees. I think they add beauty. They do, numerous benefits to the environment.
Thank you. There may be some questions.
Yes.
In fact, I have a question. That blue oak that you've pictured, do you know which one that is on the arborist report? I believe they're numbered.
I don't have the arborist report in front of me, but I could
Okay.
probably identify that later.
Well, we can try to work on that with staff afterwards. Are there other trees in particular? I asked about 2 trees. Are those ones that that you believe could be saved?
I believe these could be saved, except for possibly because of the excessive grading that they are doing in excavation, they might damage this blue oak. But I think that's a decision of approving the plan. You know, did they take in consideration the value of my privacy or the value of the trees, and changing the, I mean, no property has the 5-foot setbacks.
So just to come back to
Yes.
the tree issue, I had asked about tree number 526 and 527 that are
One of
considered
these
large
is
protected.
one of those. The blue oak is one of the ones you had asked about.
Okay, thank you.
Yes.
Other questions? Okay, thank you very much. So we have no more cards on this, and we will now close the public portion of the hearing. And we now have,
I just,
I'm sorry, your time is up. I don't know if there's
Okay,
any other
okay.
questions for you.
okay.
No. Okay, thank you very much. Your opportunity would have been to submit a card when we were considering this. We've now closed the public portion of the hearing, and so we don't have the opportunity for that at this point. So we will now close the public portion of the public hearing and ask if the commissioners have any questions of staff or wish to comment on the application. Vice Chair Hansen.
I wanted to ask staff that, although I felt comfortable with hearing the applicant's testimony, what is the town's view on the validity of the property line in between the appellant and the applicant?
The town has a certificate of compliance that was approved in 2013, and those drawings were provided by a licensed and civil engineer and stamped to be correct, and those were also recorded with the county establishing those lot lines, so that as far as the town is concerned, the lot lines
They're official.
yeah.
Okay. I had one question. I'm sorry we've closed the public portion of this hearing. So you may address the next item, or you may address at the beginning of our next meeting. Thank you. Another question, Ms. Schupman, on I saw in one of the letters that there was a recommendation of a removal of, or there was approved for the removal of the 1925 home. Is that a matter that is a done deal, or would that come to the Historic Preservation Committee?
That would be considered by the committee if that's we would address it as a pre-1941 home if that's the appropriate thing to do. Thank you.
Okay, so there'd be an additional step on that one. Okay, thank you. Other questions of staff? Okay. Are there discussions folks would like to have, or ideas or recommendations? Commissioner Janoff.
Yeah, I guess I'll start. Gosh, this is a really tough one. It's a very difficult lot to build on. I understand from the elevation that it poses some challenges. However, we do have compelling testimony that the 5-foot setback, talking about the setback, was known and possibly expected in a design. And so I have a difficult time thinking that we should throw the 5-foot approval out because there's been a fair amount of consideration around that. I'm looking at the plans of the house, and while large, relatively speaking, there isn't a whole lot of width to work with. And as they stated, when you put the garage up front, that takes up 21 foot of your width. And to have a reasonable entrance, you know, I think the design is respectful of providing that entrance without overly narrowing the house so that it becomes very garage-centric. So I think the design is reasonable. With regard to what may have happened in the past, the properties across the street, as Commissioner Badami said, we have no information on that, so there's no bearing about whether those considerations are similar, and we should be taking those into consideration for this property. So I will be supporting the denial of the appellant in favor of the house to be built as approved by the DRC.
Other comments? Vice Chair Hansen?
I agree with Commissioner Janoff's comments, and I also thought that since the other side of the property is next to a driveway, even though officially the setback is less, I actually live next to a flag lot, and you're actually quite a bit farther, as you mentioned in your testimony, from the actual house. So, I think that somewhat mitigates the situation. I also know that, this application is in compliance with town code with the exception of this issue with the setbacks, and there is evidence that that was agreed on at the point that the sale happened, even if there wasn't a contingency filed per se. And it seems like a lot of work has gone into the design to try and minimize the impacts on the neighborhood. I would also further note that the applicant did also comply with all of the recommendations of the consulting architect to make the appearance of a two-story building to be less and push the second story back a little bit. So I will also be supporting the motion to deny the appeal.
Other comments? Commissioner Badami?
I'll also be denying the appeal for the reasons stated so well by my fellow commissioners. I did note that the DRC had added conditions to the application addressing the privacy and landscaping issues, and the applicant was agreeable to those. So unless the other commissioners and chair would like to comment, I can go ahead with a motion.
Sure.
Okay. I move to deny the appeal and approve architecture and site application S-18-050, approving a request for demolition of an existing dwelling, construction of a new single-family residence with reduced setbacks, and removal of large protected trees on the property zoned R-110. I can make the findings required for a CEQA. I can make the required finding for the demolition of a dwelling. I can make the required findings for reduced setbacks on a non-conforming lot. I can make the finding that it's in compliance with the hillside development standards and guidelines, allowing an exception for a cut greater than 4 feet and fill greater than 3 feet at the rear of the property. I can make the required compliance with the residential design guidelines, and these comments and findings were made in consideration in review of the architecture and site applications per section 29.20.150 of the town code.
Okay, thank you. Do we have a second? Commissioner Janoff?
Second.
Further discussion? Comments? I wanted to add a couple of comments. I think the challenge is that, and I may not agree with everything that the other commissioners said with regard to an agreement upon sale of the property. I don't see necessarily compelling evidence that there was agreement about the setback at that time. However, I also believe that the Planning Commission is able to make findings for reduced setbacks regarding the prevalence of those setbacks in the neighborhood. And so I would say that, my finding on the reduced setback would be concurrent with the way that type of setback reduction is allowed in certain circumstances. So that's one comment. I will be supporting the motion. The other comment is that I still think that there's opportunity to improve screening. We don't necessarily review every plant and every way to do that, and I would strongly encourage the applicant and the appellant to work together to make improvements on screening so that we don't start off this new house with continued issues where they might have been resolved before construction. So I would I would ask both parties to work constructively together to try to improve the screening and the privacy issues, because it works both ways. And it also will impact the value of the home as well. So those are just some comments. So I'm going to call the question at this point. All in favor? Opposed? Passes unanimously 5-0. And are there appeal rights to this, Ms. Arnowitz?
Yes, there are appeal rights to the town council on forms available in the town clerk's office within 10 days of the decision and with fees paid.
Okay, thank you very much. So we will now move on to item number 4, which correct, thank you. The town attorney has reminded me that we do have the opportunity to speak about this matter at the town council meeting as well as the next planning commission meeting during the verbal communications period. And I would encourage the public to take that opportunity to do so. And then number 4. So, number 4 is architecture and site application S-18-060. The project location is 16336 Shady View Lane. The appellant is Matt and Carrie Curry. The applicant is Dimate Construction, property owner Alan and Caddy Colson. This is to consider an appeal of the Development Review Committee decision approving a request for demolition of a single-family residence and construction of a new single-family residence on property zoned R18 APN 532-03034. I understand that there is also a desk item, so I just wanted to check whether the commissioners have had an opportunity to review the desk item as well. Okay, thank you. And a show of hands from commissioners who visited the property under consideration, and any disclosures. Okay, Mr. Safdie, I understand you'll be giving a staff report.
Thank you, commissioners. Before you is a proposal to demolish an existing single-family residence and construct a new 2-story single-family residence on a non-conforming property zoned R1. The project meets zoning code requirements and was approved by the Development Review Committee on August 13th of this year. That decision was appealed by the neighbors to the east due to concerns related to privacy and neighborhood compatibility of the new 2-story residence. Following the appeal, the applicant has worked with the appellant and has submitted revised plans, which were included with this report as Exhibit 17, which removed the second-story balcony, updated the tree plan, and decreased the street side setback along Shady View in order to increase the separation between the appellant's residence and proposed residence. Should the Planning Commission find that the revised plans provided as Exhibit 17 are acceptable, with the reduced street side setback along Shady View Lane, additional required findings are included in Exhibit 21. And this concludes staff's presentation, and we're happy to answer any questions.
Thank you. Are there questions? Okay, my one question is has staff had adequate time to evaluate the desk item in terms of the recommendations or other thoughts that staff has at this point?
Yes, we have.
Okay, great. Thank you. So now we will open the public portion of the hearing and give the applicant the appellant an opportunity to address the commission for 5 minutes, and then followed by 5 minutes for the applicant. So the appellant is Matt and Carrie Curry. So you please come forward and explain to us your appeal.
Thank you. My wife and I have lived at 16330 Shannon Road for approximately 10 years. We developed our own home a couple of years ago, so went through this process, so very familiar with it. But unfortunately, we encountered a much different planning process than the neighbors have been allowed to undertake. And so we started submitting letters after we learned about what was planned next door, because the house was actually for sale on the market, and we learned about what was proposed by the real estate agent. And so a lot of concerns around what was being proposed, what the agent was talking about as far as these were approved plans for a 2,700 square foot home with the basement. They were ready to go in June. Needless to say, we were incredibly concerned because we had never seen the plans. Our process was different because we engaged our whole neighborhood. We got 80 neighbors around us to sign off on our plans. We literally went door to door. And the way we found out about this was because the agent said, hey, yeah, this is what these people are planning to approve. And so we immediately wrote a letter to the town saying, what's going on here? How come there's a different process than when we read the town guidelines, and what we understood the process to be doesn't seem like it's being followed here. So wrote a number of letters, got a little bit of engagement, but not really the type of engagement that we expected and that all of our neighbors have engaged in when they've developed their homes, and that was sort of the community expectation. Needless to say, that didn't occur. We continued to write letters, didn't really get our concerns addressed. And again, this has never been about not allowing the property to be redeveloped. I think we could all look at that house and realize it needs to be redeveloped. It's about developing with some sensitivity, with some awareness, with some ability to look at the context of the neighborhood and propose something that fits in, and to also be responsive to concerns of your immediate neighbor, where you're proposing something originally where it was 8 feet off the property line, where they jammed all of their highest elements right along the property line, and we were told over and over the reason for that was because, well, they had lot constraints. Unfortunately, I understand that, but our concerns were that we were bearing the burden of all of these lot constraints, including basically an unarticulated shear wall, incredible massing right up against the property line, and all we wanted to do was to be heard. And unfortunately, we continued to be blown off by the town, by the DRC, and it was only when we engaged legal counsel that the applicants took us seriously. And so we're at a point now where the applicants have proposed revised plans that I think are responsive to moving their house off the property line 4.5 feet, removing their rear balcony, which was, again, a huge privacy concern, which we raised. And I think if you look at the town design guidelines, it's pretty clear that if there's a privacy concern, a rear balcony shall not be built. But we were told time and time again that there's no problem. We're going to let this go forward. We were shocked, actually, at how this was handled. Needless to say, the revised plans, I think they're in Exhibit 17, would be acceptable, but only if the side setback is reflected and the balcony is removed, and that new tree plan is also required as a condition of approval. You want to say anything?
Just adding
Yeah.
from what my husband was saying, again, we engaged in this process 5 years ago. It was a much different experience, our process. So I think we had high expectations of how eventually we knew that property was going to get redeveloped. That was what we had told our planner. We had to actually redesign that side of our house that shares the property line from recommendations of our planner as a town architect, because we were told that it created too much of a shear wall, it was too heavy. And we followed those guidelines, and I think we just wanted to be heard. We wanted to be able to meet with the DMT, we wanted to meet with the applicants to try to resolve this. The balcony is peering down, it was peering down into the middle of our yard. We've been through this. We just wanted to be respected and to, we're not preventing this from being built. We're just trying to make it, we have to live next to each other. We're trying to be amicable, let's come to some meeting, an agreement. That's it.
Thank you. There may be some questions. Vice Chair Hansen?
I just wanted to confirm from the desk item we received, and I think that's what you just said, but it says here, the Currys wish to make clear that so long as project approval is expressly conditioned on the project's conformance with the updated plans submitted on October 3rd, 2019, which is included in Exhibit 17, including the 3 elements described above, which I won't read what they are, you will not oppose approval of the modified project. But you're not officially withdrawing your appeal, you're just saying that you wouldn't oppose it as long as the Planning Commission made those conditions of approval.
Correct. We actually were hoping to get a settlement agreement, but the applicant wasn't willing to go there. I think that would have been better for all parties, which would have resolved all of these issues, and we would have agreed to not move forward with potential litigation, but the applicant decided they didn't want to do that. But yes, you're right. If the Planning Commission approves the Exhibit 17 plans, we won't oppose those. But if there are changes that differ from those plans, then we would potentially appeal again.
Okay.
Yep.
Other questions? I had a question about the architecture, and do you have any objections to the architecture or style? There have been some modifications that have been made.
I do have a few concerns, only because we have been residing.
Please speak into the microphone, thank you.
I do have concerns only from the fact that we have lived on Shannon Road since 2010. It has become a very, very busy road. The traffic is horrible. There's actually, if you go on next door, there's issues with drag racing. So the way that the applicant has designed their driveway actually is off of Shannon Road. The original driveway is on Shady View. They will be entering and exiting their driveway right by that stop sign, the only stop sign that has the crosswalk on Shannon Road. The door is you can't tell if it's Shannon Road or if it's Shady View. It's at an angle. There is a Spanish-style home across the street, but everything else in the neighborhood is either arts and crafts, and our house is a white farmhouse. So architecturally, I'm not going to tell somebody what they can do with their home and how they design it. But I will tell you, it's a safety concern where the driveway is. Just having 3 kids and being on that road and seeing the traffic pattern, it's concerning.
And that's something we can follow up with staff. The other question I had is about the desk item. Since it's kind of late breaking, have you discussed the desk item with the applicant? And have they represented that they're in accord with the desk item?
We actually talked to the applicant prior to that being submitted, so we haven't had a follow-up conversation about that, but it seems to be reflective of the changes that we were looking for, but we haven't had a specific conversation since that plan was proposed.
Okay, thank you very much.
Yep.
Next is the applicant, and I see one card, Missy Fox, representing Kathy and Alan Colson. Is that correct? Yes, please. You will have 5 minutes. Oh, I'm sorry. I'm sorry. It says representing, so you're not representing the applicant. Okay, so I don't have a card from the applicant, I don't believe. Is the applicant here? Okay, you can fill the card out later. Thank you. I'm sorry, Ms. Fox. We will ask the applicant to go, and then you'll get a chance to speak.
Okay.
Thank you.
Sorry, I apologize for not filling out the card. But anyway, my name is Jim Whitney. I represent Dimite Construction, the
Please
applicant.
speak a little closer to the microphone.
I represent the applicant, Dimite Construction. Jim Whitney. Okay. So the Currys' final portion of their statement was that they would be supportive or not in opposition of Exhibit 17 as we submitted. And it's generally our
we're generally in agreement with that and would move to, or hope to, that you would consider the changes that are in those, in part of Exhibit 17. And we're in agreement with their conditions for that. So I don't have any further comment.
Okay, questions? You have more time if you'd like
I
to use
understand.
it.
It just, I mean, we've gone through a process per the town, and we're in compliance and have followed all the procedures set forth by the town policy, and I think we're in compliance with those. So,
Okay, thank you. Commissioner Badami.
I'm sorry, did you have an opportunity to read the town architect's report?
yes, we did.
All right. He made 7 recommendations as to the architecture. Did you take any of these into consideration or add any of these suggestions?
Yes, we did. And off the top of my head, I believe that, just looking at the drawings, the stacked rock wall was added. There was a stucco base added to the elevations as well. And I believe we added some articulation as per the report as well.
How about the decorative wood corbels at eave lines?
It was part of that as well, yes.
Okay, deep set garage doors and all windows on all
Increased-
facades.
yes, we
Okay,
increased the-
you did
the
all
frame
that.
of those,
Okay,
yes,
and
we
a
did.
decorative carriage light
Yes, we included that as well.
and second floor columns on the north balcony square, but you're, okay.
Yes, that's correct.
Thank you.
I had a question about the architecture as well. The tower element,
Yes.
could you explain how that would be compatible with the neighborhood and with the residential design guidelines?
We feel that it's per the style, the Spanish style of the home, and we actually did address some of the architects, the consulting architects' issues with that by adding the rock face siding to it, stacked rock, and modified the windows that follow the stairs in the interior stairs there. We feel that it complements the architecture as a whole.
And you feel that the tower is a positive element of the design, or is it something that you were sort of forced to do
No,
for other reasons?
that was something that we elected to do, yes.
Okay. And is it compatible with the neighborhood?
I believe it is, yes. We believe it is, yes.
In which way? And are there other homes with towers?
Well, there are no homes with towers in the immediate neighborhood, no. But I don't think that it detours from the existing neighborhood context.
Okay, thank you. Other questions? Okay, thank you. You'll have another opportunity after we hear from the public. So, Ms. Fox, I apologize before I misunderstood the representation on your card. So you have 3 minutes. Thank you.
Thank you. We are Jim and Missy Fox. We live on Shady View Lane on the south side of the Colson property. We've spoken with the Colsons a number of times since the beginning of their plans. We've seen their plans a couple of times and discussed issues. And in general, we found them to be open and amenable to any of the concerns that we did have. There is just one minor issue that has not been resolved regarding a pool pump, but I'm sure in the future that that is something that will be resolved to both of our interests.
Okay, thank you. Are there questions? Thank you very much. Next card I have is Whitney Halliday. Yes, thank you. Then that's the only other card I have from the public. So if anyone else would like to speak, please submit a card.
Hi, thank you for this opportunity to speak. My name is Whitney, and I live on Hilo Road, which is just down the street, so I'm a close neighbor. I walk down Shannon a lot and drive by that corner probably 5 times a day. And just looking at the story poles, I'm actually really surprised at how high and how out of proportion the poles look relative to the land. It appears to be an extremely small lot on a corner with super high poles that don't look in proportion to the other homes nearby. So, you know, as we're all aware, the things we can do to mitigate this is to ensure that we adhere to proper setbacks and proper placement of windows. I noticed there was a balcony, and I haven't seen any balconies on any of the homes in our neighborhood. So that was surprising to see that. And I think it's just, you know, I have no opposition to builders coming into Los Gatos and building these big, beautiful homes. You know, two-story homes are fantastic. But I think it's really important that you continue to enforce the privacy concerns of neighbors, because in the end, we just want to live in a nice private home. I just want to, you know, emphasize that I feel that your team should really not approve this project until all the concerns are fully vetted, because, you know, just from an objective standpoint, looking at it, it looks really out of place and really high and towering over the nearby homes. So I thank you for allowing me to speak, and hope that the neighbors can mitigate this so that in the end everybody's happy. The last thing you want are two neighbors living next to each other and just feeling that they have no privacy, you know. So no objection to a big, beautiful home, but let's make sure that everybody's happy in the end.
Thank you very much for
Thank you.
your comments. Any other comments from the public? Okay. We'll go back to the applicant. So you have another 3 minutes if you'd like to address anything that was raised. Yes, come forward, please.
My name is Katy Colson. My husband Alan and I are hoping to live in Los Gatos and build our home. We're very thankful for your time, and Ryan and the team at Dimate. Just some clarifying points. You, Matt, and Carrie were the first neighbors that we spoke to.
If you don't mind, if you'd address your comments to the commission.
Yes.
Thank you.
We spoke to them first. The reason our home was for sale is because my husband's father fell ill, and we thought we had to take him in, and our home today doesn't have the space. Anyhow, he's past that. We retained the home, we moved forward with the plans, we talked to them, we talked to Jim, Missy, and 30 other neighbors. And we received support from, I believe, 25 of them. Yes, we've been talking on agreements. In fact, last week we had a session to discuss those points of compromises. We have been the party that has provided any and all compromises, removing windows, changing the shape of the windows, obscuring them, the tree line, removing the balcony, proposing the extension of the space between our shared fence. But the request from them to not meet here was to sign an agreement outside this forum in which we will commit to not make any changes, and those changes will stay even if we decide to sell our home, which we think is not right. It was also proposed that we will sign that agreement so they will not sue us in the future or the city. We will not believe that is right, and that's why we ignore the request to agree, and that's the reason we're here.
Yeah. And I just want to reiterate, I wanted this meeting in public. I did not want to sign something where he had to be silenced because he was screaming at us. I didn't feel it's the right thing to not do something in public. I want to be open, honest. I want to be in front of all you guys. I don't care what it is, but I do not want to be signing contracts with third-party lawyers in the background. It feels unethical. It feels wrong. I want to get in front of the public commission. I want to tell you that this is what we want to do. We've made 20 compromises in total. I'll continue to do them. I want to do what's right. I want to do it in a public forum. I do not feel comfortable being asked to sign private contracts behind closed doors. I will not do that.
That's all.
Okay, thank you. There may be some questions. So I did have a question about the architectural style, and I know that we've had an opportunity for the consulting architect to weigh in, but the Planning Commission also has the opportunity to review this. And in the residential design guidelines, which I believe is applicable, and I'll check this with staff later, but there is an item 2.3.5 that says avoid the use of tall towers or turrets unless they are integral to the architectural style. Would you like to comment on the use of the tower or whether it is integral to the style?
We believe it's integral to this style.
And do you have some evidence or something you'd like to tell us about to demonstrate that? Either a discussion of how that architectural style generally includes towers or turrets?
We don't have any evidence at hand or as part of the project submitted. Our research and our expertise in different styles of architecture, we felt that it incorporates a spiral staircase inside the home, which is integral to the style of the interior of the home, and therefore, because the nature of the spiral staircase, it seemed fitting that it would be also presented outside the home in that manner.
And to add to that, the house across the street is a Spanish style. We personally like the Spanish style. My family originally is from the Pyrenees. The stone facade is absolutely 100% common, and then the wood beams on the inside are, basically direct copies and pastes from the family. So for me, it was personal. It came straight from the family, from, kind of our heritage.
Okay, thank you very much. Other questions? Yes, Commissioner Badami.
Adding to Chair Hudis's concern about that, if it did mean an approval from the commission so that you could move forward, would you be amenable to removing the tower?
Yeah, I agree. I don't think so.
No?
No, ma'am.
Thank you.
Okay, thank you. Okay, thank you very much. And the appellant will have as well an additional 3 minutes.
Thanks. Just to clarify, there's never an attempt to, force anybody to sign any agreements in private. It was just to make sure that there was alignment on the changes we were looking for, to make sure that the applicant submitted plans that were consistent with that. We were nervous about going into this hearing without having any clarity from the applicant that they would actually move forward with plans that answered our concerns. And we actually thought it was beneficial for both parties to sign a settlement agreement because, there was still the ability to litigate. And we thought that it was good for the applicant and for us to have total clarity on that. But we always knew that this had to ultimately be approved by either the Planning Commission or Town Council. So there was never any suggestion that this would be handled any other way, just for clarification. The other thing I just want to point out is that there really wasn't that cooperation, frankly, until we had to get a lawyer involved. So the cooperation really started happening once we hired land use counsel, unfortunately. It's unfortunate that we had to get to that point. But I think we're fortunate that we have the ability to do that. But it wouldn't have needed to get to that point if the town design guidelines had been followed. And I think you guys are highlighting some other things that are perhaps questionable about this application that maybe haven't been looked at and focused on. I think there was selective application of those guidelines to this project. Certain things were focused on, certain things that were specifically referenced by us were just ignored, and really no clarity as to why those can be applicable to most cases in the town, but for this particular situation, they don't need to be followed. And I think it's really important for the town to make sure that you guys are putting forward policies that apply to everybody fairly, not to certain applications, and they'll have to follow all of the guidelines, but others can, maybe only have a few apply to them. And I think that really creates a lot of frustration and a lot of lack of clarity from the citizens of this community. And I think it would be great if there could be some clarity given, and some consistent application across the board.
Just to add, we did briefly meet with the Colsons one time. At the meeting, we talked about our concerns with the balcony. This was their first plan, and they said they would add screening trees. They did come back and send us a plan, but that to us, that there was still an issue with their rear balcony. We offered to meet with Ryan and Sally and Joel and DeMatte and the Colsons many times in the DRC's chambers to just try to resolve this so it didn't have to come to this. We just wanted to say, hey, there's a privacy issue. We didn't even bring up in this meeting at this particular time, the turret that you're talking about, the architecture of the home. We've decided to let that go. Our objective was to address the 8 foot, we have an 8 foot setback, there's shear wall, there was no roof line articulation. Yes, they have taken steps to do that. We've had to kind of just really be very vocal with the DRC and submit many letters and a lot of meetings to kind of even get to this point. Again, you don't want to start off like this. We're not trying to prevent them from building a home. We're just asking for the applicant to just work with us. That's all we're asking. We do have a redwood tree on our property that has been addressed too. There's actually a redwood that has split into 2. It's a historical tree. We're concerned about the root system and how building the home and a pool will impact that. I mean, we've raised concerns. Why? Because we've been through this process. We built our house 4 years ago. We went through planning commission. We know the guidelines from the town. We know how this works, and we just we were hoping that there would be a little bit more of an effort, a teamwork, kind of neighborly gesture. Thank you.
Okay, thank you. Are there questions? I had one question, and that is, based on the testimony from the applicant tonight, do you believe that the 3 items in your letter have been addressed and will be addressed?
I think that's why there was some concern with that, just having to sign the agreement outside of this.
I'm not asking about an agreement.
Yeah,
I'm asking about the letter.
Address, they removed their balcony. They made it into a second part of the second story. They've provided screening trees, and they have moved. There is a motion to move their home even further from the 8 foot setback, I believe, is what.
4.5 more feet.
4.5 more, so 12.5 feet from our property line. I mean, then I'm not going, again, the neighborhood, the architecture fitting with the neighborhood, that is something that the planning commission would have to address. My concerns are in privacy.
Right. I'm specifically asking about the 3 items in your letter that were requested.
I believe, the plans attached as Exhibit 17 do address those.
They address that. Okay. Yes. Thank you. Other questions? Okay, thank you very much. So we'll now close the public portion of the public hearing and ask if the commissioners have any questions of staff or wish to comment. Yes, Commissioner Tavana.
Yeah, can staff clarify their position on the turret? I'm just curious to see where their rationale came from in approving it.
Sure. So if you look at the consulting architect's report, I apologize, I just lost it. So he does say the round stair tower is a common feature of this architectural style. Overall, the proposed design, while correct in general form, is short of the architectural details normally associated with the style. And then he recommended specific details to be added in order to address his concerns.
Could you just
Thank
tell
you.
us what page that's on?
Sure. So of the consulting architecture report is page 4, and that is Exhibit 7.
Okay, thank you. Vice Chair Hansen?
So I just wanted to make a general comment. What we're being asked to consider is whether to approve or deny the appeal of the Development Review Committee's decision to approve this project. And the basis for the appeal was the concerns of the neighbors. And if, based on the testimony that we've heard tonight, it's my understanding that that the neighbors, the appellants, have agreed, as long as the conditions of approval include the plans as attached in Exhibit 17, that they are not going to oppose the project. So that being the case, I'm satisfied the consulting architect has done a review. We have the arborists have done the review. I'm not considering this to be a complete review of the application. Rather, it's to discuss the merits of whether or not to provide a denial of the approval of the Development Review Committee. And so I support denying the appeal and moving forward with approval of the development.
Thank you. Commissioner Janoff?
Yes, I would echo the comments of Commissioner Vice Chair Hansen. And while we are not here to talk about the architectural style of the home, I would like to add, just to confirm that on page 3 as well, the consulting architect says the home is well designed in the Spanish Revival style. And I think that the presence of a turret is both architecturally an interesting feature for this style. It also is efficient with regard to the interior design of the home. It's a small lot. You're consolidating a stairway in there. I think that's a novel way to achieve that, that feature. So I'm in support of the design, even though that's not part of what we're looking at today. This neighborhood is a very interesting one. It's changing a lot. There are Spanish style homes in the neighborhood. There are farmhouses. There are craftsmen. It's a lot. There's a lot going on. So I don't find any concern with it being out of place for the neighborhood. I think it's consistent in general, and I think the style is very attractive. And I am very pleased that I acknowledge that it's taken a lot of effort and perhaps more than you anticipated in order to get to this stage, but it's really great from a planning commission standpoint to know that you can come together as separate parties, bring your differences to the table, and through hashing and gnashing, get your issues resolved amicably. It's a huge thing for us. I'm really pleased that you've brought the letter that says we are in agreement, provided Exhibit 17 is what's built. That is what has been approved, so that is what will be built. So I'm in complete denial of the appellant, and will be supporting the DRC's decision.
Okay, thank you. I just wanted to ask a question to staff for a moment. Is it the purview of the Planning Commission to review the architecture as part of the architecture and site application?
It's the purview of the commission to look at the entire application.
Okay. And is the does the commission have the ability to weigh in on the architectural style and design if it is a different conclusion than the consulting architect reaches?
Well, the town does rely on the consulting architect's architectural review, and that's what is brought forward for the decision, and that information is brought forward to you. But of course, the commission can always make its own decision should they find that's appropriate.
Okay, thank you. Other comments or questions? Staff? Anyone want to move forward with a motion? Commissioner Badami.
I'll make a comment and then I'll try a motion. I'm not fond of the turret either. Our residential design guidelines do not like it either. The town architect liked it. However, the residential design guidelines, it does encourage architectural diversity. That being said, I am going to deny the appeal. So I'm going to move to deny the appeal and approve architecture and site application S-18-060, approving a request for demolition of a single-family residence and construction of a new single-family residence on property zoned R-1-8, with the added conditions of full conformance of plans per Exhibit 17 that included the 3 elements of no second-floor balcony. The residence moved an additional 4.5 feet away from the Curry's property, and that we have an updated tree plan. I can make the required findings for CEQA. I can make the required finding for the demolition of a single-family residence. I can make the required finding for reduced setbacks on a non-conforming lot. I can make the required compliance with the residential design guidelines. These considerations were made in review of architecture and site applications as required by Section 29.20.150 of the Town Code per Exhibit 21.
Thank you. Do we have a second? Commissioner Tavana.
I'll second that motion.
Okay, thank you. Comments before voting on this? I would just add 2 comments. First of all, with regard to the architecture, I do believe that's in the purview of this commission to look at the architecture. I personally come down on the side of the residential design guidelines. However, in this case, I believe that maybe some more knowledgeable and expert members of our own commission have made the case that this is integral to the design and is done so in a way that the overall architecture is, as the consulting architect says, a good example. So I will support the motion despite my reservations about towers and turrets, and for those reasons. I would also just add a comment as I'm supporting the motion that there may be opportunities for additional screening utilizing plantings or other ways to do that, and I would encourage both parties to work together because privacy is a two-way street, and it also affects the value of properties, and so I would encourage that to go on as the further development. We don't cover every detail of the landscaping, but there may be opportunities in the future to do so. Any other comments? Okay, so with that, I'll call the motion. All in favor? Opposed? Passes unanimously, 5-0. And Mr. Safdie, are there appeal rights on this item?
Yes, there are. The decision of the Planning Commission can be appealed within 10 days in the town clerk's office on forms available and with fees paid.
Okay, thank you. So I think we may want to take a quick break. How do folks feel about that? I know the next item is probably not very long. Do we want to keep going? Yes, keep going. Okay. So we will now move on to item number 5, which is General Plan Amendment, Application GP 19001. The project location is townwide. The applicant is the town of Los Gatos. To consider proposed general plan amendments to language specific to Highway 17 in Goal TRA4 and supporting policies. Welcome, Mr. Morley.
Thank you. Good to be here with you tonight. So thank you for the introduction. We are bringing you a request for a general plan amendment, looking for the Planning Commission's recommendation to the council. To give you a little bit of background, this item came about as we were looking at 2016 Measure B, which is a sales tax measure that's been put in place With that, we have a major project that includes the improvement of the interchange at Highway 9 and Highway 17. In the course of discussions with VTA, we had the opportunity to expand the scope of that project to add some efficiencies to Highway 17. We had that discussion with council earlier in the year, and council gave us a direction to move forward with that, with the further direction that we should bring forward a general plan amendment for consideration at a future time. So we're in that process now. We've been to the General Plan Advisory Committee, as is our process, and we're now making our stop with you. The General Plan Advisory Committee did make some recommendations, and those are included in the report for your knowledge and consideration. And out of the conversation tonight with you, we'd like to work through some recommendations for you that we would bring to the town council when we hear it with the council later this year. And that concludes my report, and of course, we're here to support the discussion.
Thank you. Are there questions? We will open this to the public in a minute, but I will save my questions until after anyone from the public may want to speak on this. So we don't have any, and I don't have any cards on this. So maybe we could then proceed. Staff has anything else to add?
I think I've covered it in my initial report, and we're happy to respond to your inquiries.
Vice Chair Hansen.
Is this a time to make comment or just only questions?
We haven't closed the public hearing yet, so this would be questions of staff. So actually, since
I did
staff,
have one
we
question.
could ask questions of staff, so it's fine.
I did have one question. When the GPAC meant, and it's in the staff report, but it's not in Exhibit 3, the GPAC agreed to also make some other changes to this section of the general plan, specifically removing 4.3. And so I wondered why that wasn't stricken from the language in Exhibit 3, since it was part of our recommendation to the general plan.
So we left this, thank you for the question. We left the staff recommendation in the exhibit, and we included the GPAC's recommendations specifically as they were called out in the discussion section of the report, called out individually there.
So, so then my question is, what are we, at the Planning Commission, being asked to approve? Is it Exhibit 3, or is it the Exhibit 3 plus the comments in the staff report?
So your recommendation will be your own, and so you can include the recommendations from the GPAC. You can include additional recommendations that you might want to make tonight, or you can go off on your own and not include the GPAC recommendations. It's really your choice on where you take it.
Okay.
Thank you. I'm not that familiar with exactly how this works and how long it would take to move from studying this to implementing something. But my question is, does these changes and working with Caltrans, does that give the town the opportunity to have a dialogue with Caltrans about measures that might be taken to relieve the extreme gridlock that we have in town relating to beach traffic?
So this is absolutely an opportunity for us to engage in all kinds of conversations with Caltrans and with VTA to look for solutions. I think our big opportunity here is what modifications on Highway 17 can we make to increase the efficiency and to help keep more vehicles on Highway 17 as opposed to encouraging them to come off of the freeway and enter our local streets, which is where we really feel the pain. And so we're hoping that this is a step in that direction and really helps with mitigating traffic from that perspective.
And if I might follow up, what kind of time frame will these conversations occur, and is there any hope that might occur in our lifetimes?
Great question. Especially working with Caltrans, things are a little bit more lengthy. We have started the process and the discussion already. The reason that it was important that we started early was because Measure B is working on a 10-year funding cycle. In order to be in the first 10 years, we needed to take action, and that's why the council took that sort of that preemptive action and had us come back with the general plan amendment now. Otherwise, we would have been waiting 10 years before we could have done anything. So this is really an opportunity to get us in that first cycle. Even with that, we're looking at several years of community outreach, of project design, and then into some environmental work and construction that's probably going to take us into the over 5, maybe 6 years to get to a construction project.
Thank you. One other follow-up question. I believe this was considered by Town Council, and then it went to General Plan Advisory Committee and now to us. There were some, while it did pass the council, there were 2 votes against it. Are you aware what the objections are, and have those concerns been addressed through the General Plan Advisory process?
So I don't remember what the expressed objections were. There is some concern about widening of a freeway and whether that is the right direction to move, in that there at some point is still a pinch point on the freeway past Los Gatos, and is it really going to solve the issue? So I think the response to that is, the design and the environmental work will help to identify what the project will bring, and what the benefits of the project might be. So it's early in the process to be able to talk specifically about what the outcomes will be without being able to actually study them and look at them. And so that's the proposal of where we're headed.
Okay, thank you. Other questions? Vice Chair Hansen?
This is sort of a question from staff. If I recall there was some concerns at the GPAC meeting about the idea of the freeway, and so would it be correct to point out that under Transportation 4.4, where it says the Planning Commission and Town Council shall review all new or modified connections with Highway 17 within the town, that's the final approval stage, and then there's all this stuff before that, community outreach and all that stuff. So I guess the question is, is there protection from someone steamrolling and putting in, a big, huge, 6-lane freeway?
I think
from making this change. Yes,
that's a good point, and I think that's why there's been no improvements or proposed improvements to Highway 17 for the last number of years, is because both Caltrans and VTA acknowledge that the town has been opposed to changes in the general plan. It was one of the big considerations and one of the big requests from Caltrans and VTA, even to consider this, is that we had support of the council and that we moved forward with a general plan amendment so that we could see that, because they really want the community behind it. And they acknowledge that a significant part of the next process is community engagement, working with the community to come up with a project that we can study and bring into into our environmental work, and really get into and review, ultimately with the council having approval of the EIR when that comes forward.
So this gives you a little bit of leeway to just start the discussion, but it doesn't give authority to make it happen.
We haven't brought the bulldozers out yet.
Okay, other questions? Discussion? I will close the public hearing, and I guess that would be a further opportunity for questions of staff, but okay. Don't see any, so I would move to make a recommendation of the document as written, with the addition of the comments from the General Plan Advisory Committee, which I think are relevant and apt, and I believe there's no fiscal impact, and it's not defined under CEQA, so no further action would be required. So that's my motion. Do I have a second? Commissioner Badami?
Second.
Okay. Further discussion? Don't see any. I'll call the question. All in favor? Opposed? Passes unanimously, 5-0. Thank you, Mr. Morley.
Thank you.
And that, I believe, is the last item that we have tonight, except for our reports. So first, report from Mr. Paulson, Director of Community Development.
Thank you, Chair. So two quick things. One, the town is still actively recruiting for boards and commissions. So if you know folks who would be interested in any of the boards, historic preservation, or any of the other boards which have vacancies, the application deadline is October 25th at 4 p.m. Please encourage folks to apply for those if you know some good candidates. And then lastly, I just wanted to mention we did have a meeting last night, a joint study session with Planning Commission and Town Council regarding vehicle miles traveled as it relates to CEQA. It was really just an introduction to give everyone kind of a little bit of a foundation regarding that, and there'll be follow-up conversations over the next few months to at both Planning Commission and Council so that we can comply with new state law, which has to be done by July 1st.
Thank you. Just with regard to that last item, I was unable to attend, and I know Commissioner Birch expressed as well an interest in seeing any of the materials that were presented. I believe there was a PowerPoint presentation. Will that be available to the Planning Commission?
Yes, we requested that from the consultant Fair and Peers, and so as soon as they send that to us, we will forward that to Town Council, Planning Commission, and General Plan Advisory Committee.
Great, thank you. In addition to serving on the Planning Commission, members of the commission serve on several committees. Are there any committee reports tonight? Vice Chair Hansen.
The General Plan Advisory Committee met since our last Planning Commission meeting, and the express purpose of that meeting was to actually discuss the proposed general plan amendment that we just discussed. And it was actually a departure from the general timeline of the general plan update because of the need to update this particular amendment so that this discussions could happen relative to Measure B. So the next step for the General Plan Advisory Committee will be to receive the alternatives report that relates to the land use element, and we'll be seeing that and discussing that in November and December.
Okay, thank you. The Historic Preservation Committee met on September 25th, 2019. We reviewed 16890 Roberts Road and approved removal from the Historic Resources Inventory. We reviewed 258 Edelin and approved minor development in a historic district. And on 29 Broadway, we provided preliminary review of a proposal to construct a new two-story addition and new detached accessory structure on the property in the Broadway Historic District. So we had some activity there. I believe that the Conceptual Development Advisory Commission was canceled. There were no items on that, I think. So are there any other matters that the commission wishes to discuss? I would just like to pass on best wishes for recovery to our esteemed commissioners O'Donnell, who I understand has been spotted walking around town, and Commissioner Birch, and we hope to have them join us soon. So thank you all for your participation this evening, and to the public, and this meeting is adjourned.